Yes. It's me. Okay, go ahead and
So their authorities follow.
Yeah.
Feedback.
I think I got one.
Yeah. And maybe make sure you have change later.
Yeah, okay.
That's what you start.
Yeah, mine has the electronic Right.
We'll call the meeting of the Madison County Board of Zoning Appeals to order, please. Gentlemen, you received a copy of the last meeting's minutes. Are there any additions or corrections?
Actually, we have the 18th of August and the 16th of February. So I don't think we actually approved the August ones back in a few months ago. So just make sure we have those approved as well, if everyone's okay with what's in there.
No. Do I hear a motion to accept? Is there a second?
A second.
All right, thank you. Suzanne, you want to read the agenda for tonight, please?
Applicants, petitioners, Mr. William Rother, Belmont Farms LLC, are appealing the county planners, zoning administrators, January 20, 2021 determination letter related to special use permit application case number SU 11-2021 CWSX LLC, that the application was complete.
Thank you, Suzanne. Will Egan?
Yes, sir. Thanks for coming again. Feels like deja vu all over again here. So I'll pick up, just give a brief presentation. As you know, September 8th, the county received CWS Wireless LLC, a special use permit application for a cellular tower wireless communication facility in the Uno area. As I said before, my so many years of working in this field, this is the application, this submittal is probably one of the more technically sort of in-depth applications that we've received. And I even put it, as you will see in your packet, I even uploaded it to online. So if you did want to go look at it, it is there for the public review. Now you're going to have a really good high-speed internet connection to download it. So just in case you tried, I hope it didn't slow your computer down. So that was submitted on September 8th. And we know, according to the Code of Virginia, we reviewed it. And as the code says, and we've kind of gone over several times here before the Board of Zoning Appeals and this petitioner, that after 10 days, business days, it is deemed complete. On 10/22, we received a letter from counsel, from the petitioners, Mr. Shannon, that stated that had 13 sort of points about the completeness of the application. Now, 1 through 13, there are a few other ones that kind of go into specifics of the zoning ordinance, but pretty much if you look at that letter, is it complete, tends to sort of be pretty ubiquitous throughout the 13 points. And the very first one was, do you consider the application complete? And when we got the letter on 10/22, of course, the law says we had 90 days to respond. So my response was sent on December 11th, and that was just to question number 1, which of course, is it complete? And you can look at that in your packet as an exhibit. I believe it is exhibit 1. What's that December 11th letter, whatever exhibit that is. I'm sorry, be exhibit 2. Exhibit 1 is Mr. Shannon's letter that we received on October 22nd. So that was the subject of the last appeal. Was it complete? That was what we met on February, we met back in February 16th. I sent the letter, basically said, yes, it's complete. They challenged that letter, that opinion. And of course, you concurred that it was indeed complete. So now we have another appeal for items 2 through 13. And again, if you look at items 2 through 13, we still get into the completeness, more or less. Again, there are some sort of ones that don't necessarily say specifically complete, but it goes into some technicalities of the zoning ordinance, which again, it's been deemed complete. So my position hasn't changed. I don't think counsel for us position has not changed, but I know it hasn't changed. That at this point, it has been deemed complete. If you read through all the documents, I've tried to in exhaustive detail explain in the most recent memo that I dated on Monday why I consider it, zoning administrator considers it complete. We had a hearing before the Board of Supervisors, Plan Commission, Board of Supervisors, staff reports, all those things. They considered it. They had public hearing. The petitioners spoke as other people did, and it took all sort of comments into the consideration, and they approved it. So that's where we are. So having said that, again, the completeness it's just written as clear as possible in the Virginia Code. So that's what I will rest on. Any questions for me? Otherwise, you can. Okay.
Good evening, board members. My name is Roy Shannon. I'm here on behalf of the petitioners, William Rother and Belmont Farms LLC. This is our appeal regarding determinations 2 through 11. I submitted a letter to you for this hearing. I emailed the chairman though earlier today regarding special counsel. Special counsel is not going to represent the zoning administrator. There's no need for a motion to recuse him from participating in this for the reasons I stated in the letter. But if he is going to represent the administrator, then I would ask that this be continued so the administrator can have new counsel. Again, I laid out the reasons for in the letter, so I hope you give those considerations if that event does occur. One of the things we want to make sure is that the SUP application is part of this record. I don't know if you guys have had the opportunity as board members to review the SUP application. Mr. Webb made a representation that it was on the website, but it's actually on a separate page. It's on the Board of Zoning Appeals website. And it says the application submitted on September 8th. However, I believe it was submitted on September 3rd. That's neither here nor there, but it's on the BZA's website and not part of the materials for this hearing. And so I would ask that the board go ahead and incorporate the full SUP application into the minutes for this meeting for purposes of the record being complete, that the actual application is there. I'm happy to, and I think probably jumping right into it, the first two appeals that were made, the work session, December 22nd, you guys made your decision during a work session, and you did not think that those were, whether it was a valid appeal or not. There was no decision on the merits, in my understanding, or however, the February 16th appeal on determination 1, we asked for a request for determination. Mr. Webb provided us one determination there, and then he subsequently provided us with these additional ones that we're here for this evening. But that appeal on February 22nd, you denied that appeal. At least that's my understanding. And again, the staff report for this, the reason I'm saying it's my understanding is because the staff report for tonight seems to say that all the appeals were rejected. And I think they were rejected or denied for various different reasons than what is laid out in the staff report. So I don't think the staff report is accurate. And a lot of this does come down to accuracy. And what I'm providing to you right now is a copy of the determination that I have highlighted. These are the specific determinations that we are appealing. And why this is important, because again, I think Mr. Webb is relying on the fact that where he says it's to be deemed completed. Well, his determination said it's complete and it's deemed completed because of the Virginia law. And again, this is a BZA oversight board for the zoning administrator, interpret the zoning ordinance. And the question is whether or not this application is complete. Setting aside whether or not it's deemed complete by Virginia State Code, the question to the Madison County Board of Zoning Appeals, is this a complete application? And I'll point out, I'm going to give you, this is part 7, the SUP application. Again, I don't know if you have reviewed it. Again, I would ask that it be incorporated into the record. Now, one of the determinations that we're appealing is number 7. And in that determination, we requested, may the Planning Commission and the board hold a public hearing on the application, consider it and act on it if the application fails to demonstrate that no existing WCF can accommodate the proposed WCF facilities or is suitable as to the design or location pursuant to Article 1413-7. And Mr. Webb provides his response. And at the end there, he says, I also noted that there's no existing WCFs within 3 to 5 miles of the WCF proposed by the application. Now, if you look at number 7 that I provided to you, you open that, that's a picture there where the proposed UNO site is going to be. And over on the right-hand side, there's the Montpelier Station, and that's within 3 miles. So those rings, my understanding is those are the 3 and 5 mile radius rings. And this is the whole point of this appeal, as well as the other appeals, is we're trying to identify what is the process here in terms of determining whether these applications are complete. Because when you look at number 7, the response that's provided, there's also a gratuitous, I note that there's no existing the WCF, the wireless cell phone facilities within 3 to 5 miles of the proposed application. That's wrong. It's wrong. The application actually shows where the tower is located within 3 miles. So part of our concern here as the adjacent nearby owners of the land who are directly impacted and aggrieved by these decisions is, are these applications even being looked at? Because the reliance for the administrator at this point is, well, after 11 days, the state law says it's deemed complete. So does that mean it's not being reviewed? And so when you look at the application, and as we've laid out in number 10 of our appeal, that is request number 10, we have to have the requirements. 9 of 24 were actually provided in the application. There's a lot of information is missing in these applications. Doesn't matter how thick and how many pages that we're appealing. It says, yeah, there's no cell phone towers in that area. There's no wireless facilities in 3 to 5 miles. And then there's one within 3 to 5 miles. That to me, that's a problem. That means it's not being reviewed. And when 9 of 24 issues are being identified, only 9 of 24, that's also a problem. So people are submitting incomplete applications. The zoning administrator is saying they're complete, and they're not. And that's what we're appealing, because when the Board of Zoning Appeals, when you look at it, or for that matter, when the Planning Commission and the Board of Supervisors review stuff, they should be looking at the whole picture. And if someone's just putting, filling out some paperwork, but not all of it and all the requirements, then to me, they're not doing their job on that aspect. And I know it's very hard for the BZA because you're supported by staff. And I've sat on Virginia jurisdictional boards as well. And it's difficult to say, wait a second, maybe we're right on this and that the application isn't complete. And that's what we were asking. Is this deemed complete? And that was the previous determination. But in this instance, is the application complete if it does not comply with design considerations required by 1413.7? He says it is. We say it isn't. If it's not there, is it there? If it's not submitted, is it deemed complete? And the same thing with request number 6. We already went over 7 and 10. Is the application complete if the applicant doesn't include all materials, requirements, certifications, affidavits, assurances, or agreements, and other documents and information required by provided the signed written statement required by 1413.10? And I'm quoting from his letter, which I know there's a couple omissions that he put in there. I don't think it was intentional. I think it was just typos. But we're at that same point. He thinks the application is complete, and the reliance on, well, state code says 10 days later. The BZA is not here to interpret state code. They're here to interpret the Madison County zoning ordinance. And in terms of being selected to be on this board, that is where you guys are identified. That's your task in terms of identifying that. I would also mention that the approval of the minutes, I didn't think it was appropriate for us to object, but the minutes from the last meeting says you denied our variance. You didn't deny our variance. If you denied anything, it was the appeal, which that's the minutes that were in the packet. Again, part of this is the attention to detail. We're going to have a tower like this go up, and there's other opportunities to put it somewhere else, especially given the negative impact. Even if it's going to be put here permanently, you would think that the due diligence is carried out. And in our appeal, when you're missing analysis and you're missing requirements, the BZA basically, by upholding the zoning administrator, saying we're okay with that. We're okay if there's incomplete applications. We're okay if it's missing the analysis that's required by the zoning ordinance. And even if there's statements in there that are contradictory to the facts, we're okay with that too. And again, when I look at it and we ask those determinations, a number of you may say, well, you're just down here. This is your fourth technical appeal. And no, I mean, this is the details that's required by the zoning ordinance. And the zoning administrator doesn't think that he thinks it was complied with. We disagree. It's a classic appeal. I'm happy to go through more. Again, I would move that the entire SUP application be included because it's on the website, on the BZA's website, but it's not on the link for this meeting and for this packet where it's actually part of this record. Because on challenges, I do want it to be part of this record. I'm happy to answer any questions about the particular requirements or submission requirements, but If you looked at my appeal, I think it lays out just very simple. And this is a simple issue. Is it complete? Not deemed complete. Is this complete? Does the BZA think that the application is complete according to the zoning ordinance?
On this map you gave us, all the dots, they're towers, is that correct?
It is.
Okay.
And so there's an important consideration of the 3 and 5 mile range and how it overlaps. Again, Mr. Webb is absolutely correct. This is a very technical type issue. And when you look at the Mount Pelier site, that's within the 3 miles. And there's even in the application itself, it's the one that I've seen that it has, very color coded provisions, shows the different coverages and things like that. But there was also a number of things that were just not there. And I think probably one of the essential ones is, if you look at request number 6, is the application complete if it fails to demonstrate that no existing WCF can accommodate the proposed WCF facilities or is suitable as to design location pursuant to Article 1413(7)(a). And so the application, this is what the application is missing. It's missing the required analysis that, quote, no existing WCF can accommodate the proposed WCF facilities or is suitable as to design location pursuant to Article 1413(7)(a). There's supposed to be an analysis that says, hey, look, any of the towers that are out there, they can't accommodate additional space. It's not suitable, the design, the location, it's not there. That analysis was missing from the application. And the default that the Board of Zoning Appeals, if they agree with Mr. Webb, what they're willing to accept is, well, after 10 days, if Mr. Webb doesn't pick it up and review it, it's deemed complete, so we don't care if it's complete or not. And I think that's the distinguishing issue that we're trying to demand here is this application complete, not deemed? And right now, the BZA upholding the director and say, yeah, it's complete. And you're saying if he doesn't do anything for 10 days and never looks at these applications, they're deemed complete after 11 days. And to me, this is about Madison County zoning ordinance and these applications as they come in through here, not necessarily about the state law in terms of what's deemed after a certain number of days. It's whether or not he's doing his job and if it was complete. So yeah, the picture, to go back to your original question, this picture, those represent towers.
Well, if you look to the left of the site, you don't have a tower within 3 to 5 miles there.
Well, I think it's within 3. And here's the thing, Mr. Chairman, I would agree. You don't see it there. And the analysis of that would be really great, but we don't have that. And that's the problem, is the analysis isn't done. So when these site providers for the WCFs are going out there and identifying locations, once they get a property owner that's willing to do it, they'll throw it up there and they'll deal with it the next one. That's not the intent of the ordinance, is to make sure that you don't have these things springing up all over the place and that they're actually necessary. That's why there's additional requirements in space on these towers for putting the public safety, for their.
Do you think maybe that the tower company decided that maybe that area needs to be covered?
Well, I think, and part of the other thing, what we don't have here is we don't have the analysis to show the other sites that they were also considering, in the 10 sites and where those are located. I know Somerset was, my understanding is that was one of the sites that they were looking at and they identified, but there's 9 other sites. And they're supposed to go through saying, we checked this place, we checked this, there's really no other, this is really the only place that it can possibly exist. And again, this is and I mentioned this a lot during the last appeal, and I guess I'll go ahead and pull up the specific language. That on these type of towers where it's located right now, this is 1413.5, the alternative hierarchy. The following is a listing in order of preference of the types of WCF facilities preferred by the county. Attached 1, 2, 3, 4, and number 5 is the non-concealed WCF. This is the worst type of tower that the county prefers. They prefer ones that are attached WCFs, or 2 WCFs co-located or combined with an existing one, 3 mitigation of an existing WCF, or 4 concealed freestanding WCF. This is number 5. This is the non-concealed WCF. This is the lowest level priority, and yet it's missing all this analysis. So you would actually think that the lowest level preferred preference by the Madison County would have the most scrutiny. And what we're saying is we don't believe there was any scrutiny because the entire application is not there. So there may be a lot of reasons why there may have been other locations and other analyses, but it's not an application. And part of it is what I have to question is if it's not in an application, is there a reason? Are we missing something? I'm not imputing anything on the applicants, but that's one of the things. If you're missing something, then does that mean, well, maybe there isn't anything there? And maybe there was no analysis done. Maybe it was rubber stamped. But again, the requirements are significant for a reason. And when the requirements aren't being met, then that's what we're objecting to, what we've attempted to try to identify here.
Can I ask you a question?
Sure.
I'm confused. I think you made a comment that you said we're not, in your opinion, I assume you were saying not to follow state code, it's not to satisfy our local ordinance?
No, the zoning ordinance, the Board of Zoning Appeals selected by Madison County, it's not an elected position, it's an appointed position, but it is tasked with overseeing the zoning ordinance. So in terms of the Madison County zoning ordinance, then that is what this board is oversight of.
And no consideration to state code?
No, I think that when in terms of the appeal process, I mean, you're to give deference to Mr. Webb, the administrator. This is his, in terms of the ordinance, this is what he deals with. This is when you are acting in a legislative capacity for variances or permits, it is more legislative and you're making a decision there of discretion. On an appeal of his decision, you're looking at that, you give him the discretion. However, if the appeal is appealed to this Virginia Supreme Court, or not Virginia Supreme Court, the Circuit Court, they're acting in a appellate type capacity and they give deference to you, but the Circuit Court has the authority to incorporate and interpret all the zoning ordinance as its applicability to the higher up Virginia State Code, which makes sense. The Virginia State Code is approved by the General Assembly. And it has a lot more implications than just Madison County. The Madison County Board of Zoning Appeals deals with the Madison County ordinance. I imagine if we go over to Orange County, they have probably more or less, I don't know what they have, but so your bailiwick or area is the zoning ordinance for Madison County. Not the interpretation of state code. It's the interpretation of the Madison County zoning ordinance.
Okay.
If anyone has any further questions. And then I would make a motion I can't make a motion, but I would ask that you include the entire SUP application, and whether it's the one downloaded from this site and put in with the minutes of this meeting, I'd appreciate that. And I'm happy to answer any more questions if there's any public comment.
Good evening, board members. My name is Rex Edwards, local attorney, represent CWSX LLC. You probably are used to seeing Butch Davies standing here. I have been assisting Butch since this matter has taken on a life in the circuit court, and he's out of town today and has asked me to appear on his behalf and on behalf of the applicant of the SUP, just to address the limited issue tonight as to whether or not the appeal for the issue of completeness is appropriate. Having listened to Mr. Shannon's comments, I concur in his factual correction about the September 3rd filing date of the SUP as opposed to September 8th. With regard to his, I believe there's a request for a continuance with regard to this letter that was handed out to you just before the start of the meeting that I received by email by way of copy, reflected on the letter at about 5:23 p.m. today in advance of this 6 p.m. or 6:30 start. And there's this statement in the third paragraph that says, when the BZA is acting in a judicial capacity, the canons of judicial conduct for the Commonwealth of Virginia apply. When I first started practicing, I had the pleasure of practicing routinely before the Honorable Lloyd Sullenberger, and Lloyd Sullenberger routinely would ask me, Mr. Edwards, what's your authority for that proposition? And I see no authority cited in this letter. And so I will tell you that, again, having only received this at 5:23 p.m., I know of no authority that supports that proposition. My review of the judicial canons specifically has a paragraph which indicates the applicability of the judicial canons. And in the brief review I was able to conduct in the time afforded, I see nothing that indicates that these judicial canons apply in the context in which the letter of March 25th, 2021 asserts they do. So we certainly would object to any continuance for the reasons requested or set forth in that letter. On the ultimate issue that brings us here tonight, this is not a question of asking you to interpret the Virginia Code. There's nothing ambiguous about the code. Contrary to Mr. Shannon's arguments, we don't think that this board or any locality's board acts in a vacuum, immune from Virginia law. The Code of Virginia is not ambiguous. The Code of Virginia is very clear that under the procedure that is uncontested as to how this application for special use permit was filed and proceeded through your policies, it is complete. Now, this language deemed complete versus the effect of being complete is a little bit of smoke and mirrors, I would submit. The statutory language is that it is deemed complete. And the effect of that is that it is complete. And so for that reason, I would ask you to concur with the earlier determination that the application is complete. Thank you for your time. Be happy to answer any questions. Thank you.
Good evening. This is the third time, I believe, that I've had the opportunity to present argument to the BZA. And those occasions are all connected because you decided on December 22nd in the first two appeals that Mr. Rother filed that the application was complete. And deemed complete means it's complete as a matter of law. It means that it doesn't matter about all the issues that Mr. Shannon is trying to raise. He wants you to go through hundreds of pages and compare those to the ordinance. And he says that the zoning administrator, this is the first rather incredible statement. The zoning administrator, Mr. Webb, who I represent tonight, is supposed to ignore the state code and in the exercise of his duties. That's crazy. Absolutely crazy. Even crazier is, and wrong, not just crazy, wrong, is that this board is supposed to also ignore the state code in the exercise of its duties. I'll bet you they didn't teach you that at BZA school. If you went to BZA school, that is not the law. And he suggested tonight that the time when the state code comes into play is when the circuit court gets a hold of it. How much sense does that make? So Mr. Webb is supposed to ignore the state code and make decisions. Then the board is supposed to ignore the state code and make decisions. And then the circuit court can come in and say, you ignored the state code, you're wrong, you're reversed. That's just plain not the law. So when you see that word deemed complete, it really means that it is complete. Now, if I could for a moment, I think I handed out to you all the last time copies of the state code. And I'd just like to walk you through this. Did I give you all enough?
Yes, sir.
Okay. So Mr. Shannon said this appeal is very simple. It is very simple. I agree with him. That's about the only thing we agree on. Paragraph 1 in 15.2-2316.4:1. Paragraph 1. That's all you have to know. Within 10 business days after receiving an incomplete application, the locality shall notify the applicant, shall means mandatory, that the application is incomplete. Now here, as Mr. Webb said, there was no notification of incompleteness, none whatsoever. And I think Mr. Shannon was right. Mr. Edwards was right. September 3rd was the filing date. So we have 10 business days after the filing date, and September 18th is the 11th business day. There was no notice. So therefore, the application shall be deemed complete. It means it is complete as far as the law is concerned. None of this other stuff matters. Just as a sidelight, I'd refer you down to paragraph D in that section. That's even stronger than the deemed complete, because if the application is not dealt with within a certain amount of time specified in the code, it's deemed approved. There's nothing else to happen. If it's deemed approved, it's approved. So these provisions are what controls Mr. Webb, controls this body, controls everything, controls the circuit court. And that is the law. Now, Mr. Shannon stated and I'd like to go back for a moment. You all tonight approved your minutes for the February 16 date. Within those minutes, he made the argument that you heard tonight. Mr. Webb should ignore the state code. The BZA should ignore the state code. It's very simple. Yeah, it's very simple if you ignore the state code, but it's very wrong also. He also said that whether or not the notice of incompleteness is issued late is something that is not before the body, not before this body to determine. And it's okay for the BZA to ignore the state code. That's just flat out wrong. You decided this case 3 times. I don't know why you have to decide it 4, but we'll decide the 4th time too. There's simply no authority of which I'm aware that the BZA or Mr. Webb can ignore the state code. You have to go by the state code. You mentioned hierarchy. The hierarchy is the zoning ordinance is here, the state code is higher. General Assembly is higher than the county. Sometimes that's kind of unfortunate. We don't like that sometimes, but it's a fact of life. And absolutely. And the bottom line is that we all have to abide by the state code, not ignore the state code. Now, I have prepared, if you agree with the arguments that Mr. Edwards and I have made, I have prepared a motion that if you read the four lines that are in the motion, it's like 2 motions. You read the 4 lines on the first page, that basically adopts what's on the second and third pages, or a second page, and then you can sign the motion if you agree. If you don't agree, then I can't have any control over that. Let me give that to you so you can read it.
One short. Oh, I know.
I'd be glad to answer any questions you all may have.
Any questions from the board?
Thank you very much.
Thank you, sir. Would anyone in the audience like to speak?
My name is Mike Fisher. I'm from the question seems to be tonight, complete or not complete, which I guess the lawyers understand all these questions, but I know this. The tower that we need desperately down at, will never be complete if Mr. Ruther continues to come in front of this board over and over again with the same appeal. Another question I have is Mr. Ruther states in his, if this is accurate, in the minutes that his signal from his property is excellent. I was on Race Ground Road today, and this is all I can afford. I can't afford whatever he's getting excellent reception, but the best I got just for a few minutes was 2 bars. But you go over the slope, no bars. No bars on 231 in front of his house. No bars throughout that area all the way through the circle and all the way to the railroad in Somerset. Somerset site, if you go back through this company's history of trying to get a tower down there, Orange rejected that. His lawyer speaks of the Somerset site. He talks about that. But this is not the first time this tower company has tried to get a tower in that area. It's time to erect the tower. The kids need it. The emergency services needs it. And we need it. Thank you.
Thank you. Anyone else want to speak?
We've already heard of one more.
Want to clarify here, in terms of the determinations that we're seeking here, the determination that on the February 16th hearing was on the issue number 1, was it complete and deemed complete? In our request number 5, what we were seeking was, is the application complete if it doesn't comply with the design considerations required by Article 1413-7 of the zoning ordinance? I mean, that is not whether it's, and he said, as I mentioned to you in your letter dated December 11th, the application was deemed complete. Well, that's not really the answer. What we're appealing is the application complete if it doesn't comply with the ordinance? Not in terms of the state code, that wasn't the request for the determination. He may want to point to it and say, well, this is it over here. But when you look at my request, is the application complete if it doesn't comply with the design guidelines required by 1413-7 of the zoning ordinance? Question mark. That's it. Is it complete if it doesn't comply with it? Same with number 6. Is it complete if it fails to demonstrate that no existing WCF can accommodate the proposed WCF facilities or is suitable as the design location? Is it complete if it doesn't do that? Same with 7. Everyone was a little more involved in terms of whether or not the planning commission, the city, or the board of supervisors can hold a public hearing or act on it if it fails to demonstrate that it can accommodate the proposed WCF facilities or are suitable as the design location. And number 10, is the application complete if it does not include all materials, requirements, certifications, affidavits, assurances, written agreements, or other documents and information required be provided the signed written statement required by Article 14, 13, 10. And Mr. Webb, the zoning administrator, says it was deemed complete. That's not the question. And then at the bottom it says, therefore the application was complete. So if the application is complete, if it doesn't include all the materials that are required, it's okay, it's complete. And this is the fine issue of, if it doesn't have it, then you should overturn Mr. Webb and say, no, the application is not complete if it doesn't have this information. Not whether it's deemed complete because after 10 days, Mr. Webb didn't do anything. That's not the request for determination is the application complete if it doesn't include all the materials, requirements, certifications, affidavits, assurances, etc. He says, yeah, it's complete. We disagree. The Board of Zoning Appeals, the lawyers for the county, Mr. Webb, yourself, the lawyers there are saying, well, no, he said it's deemed complete, so it doesn't matter. Don't worry about it. It's the state law. That's going to trump everything here. That's not the question that's being proposed to Mr. Webb when we asked him, if you don't include all the stuff, materials, requirements, the certifications, is it deemed complete? He says, well, I waited 10 days. I didn't do anything, so it's automatically deemed complete by the state law. So therefore, the application was complete. That's not the thing. Is it complete in terms of under the zoning ordinance? So you guys can absolutely overturn Mr. Webb and say, no, it's not complete. You've got to have all the information. Now, what state code may or may not do, that's not what's being asked. And so I just want to make that very fine distinction there, that this is an issue of, when you look at the zoning ordinance, if it says you have to pay a fee and they don't pay a fee, does it get processed? Probably not. I know if I didn't pay the $300 fee here for the BZA appeal, I wouldn't be standing here. It wouldn't have been complete. I wouldn't have satisfied all the boxes. But if it's a cellular wireless facility, they could give you a stack of paper as long as it's big and doesn't have all the requirements, then that's okay. But I bet you if they didn't provide a check for the application fee, that probably, in terms of requirements. So that is the finite issue here. It's not in terms of what is deemed complete is. If I'm supposed to have A through Z and I omit 15 letters, is that a complete alphabet? No. Is this a complete application? No. He thinks it is. We disagree. Thank you for your time.
Mr. Chairman, may I
Yes, sir.
make a point? So what you just heard Mr. Shannon say is that they can come in and ask hypothetical questions of the zoning administrator and demand that they be answered, and then appeal that decision to the Board of Zoning Appeals. Well, that's wrong. The reason that's wrong is that the statute that provides for appeals to the BZA requires that any appellant be aggrieved. That word aggrieved is in the statute. It has to be aggrieved by the decision. Well, if it's deemed complete, then they're not aggrieved at all by any decision. If it's missing this item or that item, the issue is not whether it's missing an item. The issue is whether it's complete. The law tells you what the answer to that question is, and you've decided it 3 times before. Thank you.
Thank you, sir. Anyone else wish to speak?
Mr. Chairman, you ready for a motion?
Yes, sir. I'd like to hear a motion.
Okay. I move that this appeal be denied, and I would like to include the wording as presented by the attorney in writing. I don't think it's necessary that I read everything that he presented to us, but I would like to include that in my motion.
Okay.
So that this appeal be denied, and the only thing I can add to that is have confidence in what the Board of Supervisors and the Planning Commission has already done. And I'm sure if for some reason it was not complete, they would have aired it out at their hearings and taken care of that. And I understand what the Dillon rule is. And I'm not going to ignore what state code says. I have nothing else to say.
Thank you, Rod. Is there a second? Agree with Rod?
You like to do a vote?
What is it?
You've heard the motion to deny the appeal, and it's been seconded. Let's do a roll call vote. Lillard,
Yay.
Laura,
Yay.
Taylor,
Yay.
Coppedge,
Yay.
and Long is yay. It's unanimous.
Do we sign this anywhere?
Sign one.
Suzanne, you can get coordinate them signing it.
Yep.
Good, okay, thank you for coming.
Sign up at their name?
I'm going to pass one down to you to sign.
Oh, okay.
Sign one
Okay.
and sign it rather than just check it.